Well, Carloway reports a very comprehensive review of the matters that were in his remit, which is basically about the questioning of suspects and about the convention rights relating to suspects, people who have been arrested and taken into custody. It aims to address the concerns that were raised by the Supreme Court in HM Advocate against Cadder, and I think if adopted, many of these will achieve that. Most of these will achieve that. I mean, obviously, they are general recommendations. There is a great deal of detail to be worked through. In general, it's a very good review and a very positive way for modernising our law in relation to that particular topic. Particularly like the concept of simplifying arrest and the concepts around vulnerable suspects, letters of rights for suspects, and the package relating to interviewing of suspects is good, and is a good way of modernising our law. In a sense, it's a bit of a pity that the report almost seems to have been completely hijacked by one topic, and that's the topic of abolishing the law of corroboration, which is both controversial and, may I suggest, appears to be a little bit out of place in the context of this report, because it appears to be the one area which has not been fully thought through. There has been some work carried out in the sense that there was some research referred to, carried out by Crown Office, and the details of that research are set out in an annex to the report. I would have questions about what that research actually achieved. And I think it is, if you look at the research, it is research into cases where the case had been started by way of petition, but terminated because after investigation it turned out there was a lack of corroboration, there was insufficient evidence. And these cases were revisited by prosecutors. Now, one of the things that you can't do is check the research because it contains information about real people, and that information is confidential. But assuming that they're correct and decided that in these cases, without having to consider corroboration, there would then be sufficient evidence to proceed. They then came to a conclusion which was entirely a set of subjective judgments as to the likelihood of these prosecutions being successful. And we know, for example, that Donald Finlay, in a newspaper article, challenged whether they could come to that conclusion or not. Now, we don't know, because we don't know what the basis was for coming to such a view. And the report bases a lot of its reasoning for abolishing corroboration on the basis that corroboration may not avoid miscarriages of justice. So perhaps wider and deeper research has to be done. Much broader research may be required. We might need to see what the public think about the idea of one of the principal safeguards of Scots law for the public being taken away and completely abolished. The principal concern we have is that the proposal is a very stark one. It is the complete abolition of corroboration. It's not a sense of looking at changing it from a quantitative concept to a qualitative one, which is really the principal criticism, that we've gone too far down the road of a numbers game, and we need to get back to this original idea of supporting allegations and finding evidence that strengthen a particular allegation. What is actually being proposed is that we just do away with it altogether, and that we are left with a situation where a person could be prosecuted on the completely unsupported testimony of another person.